We're here with Herbert M. Wachtell, the uh, head of the litigation department, the senior litigation partner of Wachtell Lipton, and one of the founders of the firm. Uh, and we're going to discuss uh, three of the landmark Delaware decisions that Mr. Wachtell uh, argued and was uh, the chief of the team. Uh, Starting with Revlon, uh, how do you recall the origin of our firm's involvement in the development of the strategy?
Largely, I don't. Um, I know we were retained. I recall there was a massive search for a white knight, and we first finally came up with Forsman Little. I had to refresh my recollection on that. And the strategy was to be very, very, very careful in board meeting. Our firm worked on takeover defenses and the like with a very integrated team of corporate lawyers and litigators and anybody else who's required, obviously tax or so on. And Marty Lipton was heading the corporate side of the Revlon defense, as I recall, and was being excruciatingly careful as to how the board was handled and the problems on the matter. And there were stages along the way. There was the bond issue, which I've refreshed myself on. And then ultimately came the real choice before the board of whether to go with a Forsman Little offer, which had a no-shop clause and which required a breakup fee in the terms of a very favorable share of, I think, 2 divisions. I have no recollection of this. This is all refreshed my recollection because I read over the transcript of argument before Justice Walsh, or Judge Walsh at that time in the Chancery.
Going into the case, did you have any kind of premonition of how much of a landmark Revlon would represent? It's probably, by its name, the most easily recognized decision in Delaware law in the merger and acquisition field. Did you see that coming, or it was...
Not at all. Not at all. The issue that the court eventually went on and made it a landmark decision was if you were in a takeover mode, you have to treat people fairly, you have to do everything reasonable to get the highest price, et cetera, et cetera. Frankly, that was being done in Revlon. Ironically, I'm going to be impolitically correct now. I think the Revlon doctrine to that effect is perfectly sound. I've always thought that Revlon on its own facts was wrongly decided.
And was that because of the note holder issue, or the note holder issue and other aspects of the record, and how the court saw what had happened inside the Revlon boardroom?
I'm glad we started with a case that I lost. But I only argued it in Chancery. I did not argue it in the Supreme Court, unlike Time Order in QVC where I did. And the Chancery argument, very little allusion to the note holder issue. It was mentioned by the judges, I recall, because I read the transcript in one point. But the real argument in Chancery was that this was a board that was faced with a choice, and Revlon had been playing this game, whatever, I guess it was called Pantry Pride, but it was...
That's right.
It was Pantry Pride was playing the game. I should not dump all over Pantry Pride, which became Revlon, because they've been a client of our firm now for many years. But they were playing a game, whatever anyone else offers, we'll up it by 25 cents. And this put the board in a very, very difficult situation. And ultimately, Forsman Little said, enough, we're not going to be a stalking horse. And we're prepared to make a very major rise, but there has to be a no-shop clause and we have the breakup fee. And the things that seem to, Judge Walls, the Vice Chancellor, gave me a very rough time on argument, which eventually led to what became my pivotal argument. He was, if you read the agreement, if you read the record, well, there was no negotiation, was there? Well, Your Honor, yes, there was. I was getting a very hard time from him. But there was no particular emphasis. At one point, indeed, he mentioned the bondholders, but that was not the thrust of what seemed to be troubling him. And eventually, I decided, maybe I decided in advance, but it certainly was accentuated by the fact that I was not in a winning mode based on the judge's demeanor and questions and the like. I decided to make a very, very strong argument, and I can actually read it to you now if you want. And then I came back and see if I can find it. And then they came back to hit it again periodically. But the irony is usually, Your Honor, when people come in after the fact and say, well, here I am, I'm really prepared to do more if only the board had left the auction open. This is usually rejected by the courts who say the board has settled the deal. But usually it's rejected in the context where the disappointed suitor comes in and says, I'm willing to do better if only they left the auction open. What do we have here? They come and say, even now, we're willing to do worse. And then I hammered that theme, that they had never said they were going up, they had refused to go up, and basically they were seeking to enjoin, as I recall, Forceman Little and go forward with the deal with an offer which was worse than the offer on the table. And there, suddenly, the judge was silent. I did not get, I don't believe, I could look again, I don't think I got any kickback on that argument, and because it was sort of unanswerable. It was effectively an unanswerable argument. And when I made the argument, I knew that in terms of the courtroom, I would probably win, but in terms of the matter, that was not sure, because that argument was so powerful, I did not see but how Perlman, Pantry Pride, could do other than to raise their offer and raise it very substantially, because they were considerably below the Forceman Little offer. And I have a very vivid recollection, having thought that and known that. I got into my car. I always drive to Wilmington in those days. I got into my car to drive back to New York. By the time I arrived in New York, Pantry Pride indeed had made a massive raise. And it was fun. It was not a 25-cent raise. It was the topping bid too. It was a lot of money. Well, maybe it was a lot because we were already under, but it was a major raise. Now, theoretically, that should have made no difference in the outcome of the litigation, because theoretically, you view the board action as of the time that the board acts. But that was not the reality. And I think that the fact, highly beneficial to the shareholders. They got a lot more money. But I think it had a risk that we weren't going to win the litigation. So it was a rough call.
What about the aspect of Revlon that deals with whether the board could consider the interests of constituencies other than stockholders? Had you seen that as an issue that was even open under Delaware law prior to the decision?
Not really. And again, if the Delaware court feels that that's a valid doctrine, very hard for me to quarrel with it, though. I think a more broader view, is that there are many constituents, and should be many constituents, in a way that the board has to look to, and I think that view has gained more currency over the years. But on the facts of the particular case, it was not correct, because it wasn't just a matter, did they or did they not have a legal obligation to the bondholders, but those bonds had just been issued. And the evidence was that the overwhelming majority of them were still held by people who had only days before been shareholders. And as a practical matter, there were conditions to the force little offer and a litigation out. There clearly was going to be litigation from the bondholders. So on the facts of that particular case, and there was some waiver required. I don't remember particularly, but I saw a reference to that when I was
Covenants.
reading. On the facts of that case, even if there was no general obligation to bondholders, that should not have been the holding of the case on the particular facts of the case. That's why I say I really don't have a quarrel with the doctrines of Revlon, but I did not think the case was correctly decided on its own particular facts.
One of the things that I remember from that period was how quickly these cases were litigated and how little time, at least in some cases, there was to develop a full record. Was Revlon a case where you felt that, and I'm not suggesting this one way or the other, I'm just remembering, and I looked at some of the dates, the short period of time between some of the actual events and the hearings. Did you feel as a litigator and a very experienced, distinguished litigator in many forums, how much impact, if at all, did the very accelerated nature of these cases like Revlon have?
It certainly put a huge burden on the preparation, the preparation of the briefs, the preparation of reply briefs, the preparation for oral argument and the like. But it was part of the game, so to speak. You expected it. These were preliminary injunction motions. Preliminary injunction motions should come on very quickly and should be decided quickly. So I don't remember I remember feeling great pressure to get everything done and get it done superbly. But I don't think I ever felt that anything was neglected because of time constraints.
Anything else about Revlon that you recall or that you'd like to explore?
Paramount's number 2 guy sent me a bottle of champagne at a restaurant a few weeks later.
Well, as I say, in a sense, both Time Warner and QVC are cases that were dealing with the aftermath of Revlon, where people had to decide what triggered Revlon and what it meant if Revlon was triggered. So why don't we talk a bit about Time Warner, which I think in its time probably was one of the most heavily contested and most heavily covered in the news media cases, although QVC Paramount certainly gave it a run for its money. What did you think the best argument we had, our side, in Time Warner was? Or if you have more than one?
I think we had more than one. I think the best argument we had, but there was more than one, was just the one that shows up in the opinions, that the way the matter ended up, essentially it was not Revlon, because the company was still going to be publicly held, a broad array of stockholders, combined companies, so on and so forth, and therefore it was not a sale of Time Warner. If anything, I remember we argued, if you look at it, it was a sale of Warner more than, it was peculiar because I remember if you went back, Warner was never, Warner did not want to say it was being sold. On the other hand, one of the arguments I was making, as I recall, was the sequence of argument was I didn't argue first for our side of the case. Bob Jaffe of Cravath argued first for time.
Right.
I was arguing for Warner. So I'm sort of saying there, here we are, no one's accused us of any bad faith, breach of fiduciary duty, anything else. We had no conceivable reason to think that the Time Board was guilty of any. And what, you're going to leave us stranded? And now we're in Revlon mode and someone's going to come take us over? You know, we had a no-outs deal precisely because we were not prepared to put ourselves in that situation. I remember that was one of the arguments I sort of hammered at the end. But so the key argument was this isn't Revlon at all. This is a diffused body of stockholders. And when I went back, and I actually had, months ago, I found the transcript lying around my office. I actually read it. And paradoxically, I won the QVC case on my Time Warner argument because I said this is not the case, for example, if you had a company that's controlled by a single person taking over Time or whatever it was. And then then we had so many arguments on the thing. We had the argument that the offer was conditional and the long duration and so on. But I think a key argument was that Time, you know, this deal was entered into, nothing to do with Paramount. And who said that these people have to freeze their corporate life because Paramount would choose to take over Time and to make it more convenient for Paramount to take it over Time? And that was a very cogent argument, extremely cogent argument. And there were two things I remember that vividly stick in my mind about Paramount, the Paramount argument, the Paramount case, and then I can tell you an anecdote. I recall waking up at the DuPont Hotel in Wilmington that morning. For some reason, you can go back and check. I think it was a Tuesday. This is Chancery Court now.
Okay.
This is Chancery Court. And I suppose I had the Times delivered to my room. And I picked it up. On the front page of the Times, there was a story about the argument. And it proceeded to quote John Coffey from Columbia Law School to the effect that I did not have a prayer of winning, which was a wonderful way to wake up and walk into the courtroom. But of course, John Coffey did not know something when he opined that I knew. And as I say, I didn't argue first. Bob Jaffe argued first. But early on, as I recall, in my argument, you talk about the speed of the proceedings. Our partner, Peter Hine, had taken a deposition of Marvin Davis, who was the chair and CEO of Paramount. And Peter, who was a brilliant lawyer, asked Marvin Davis, and I can't give you word for word, well, if this deal really goes forward, what are you going to do? And Davis answered along the line, oh, well, we will review our options. That may be word for word, but it's pretty close. And I became ready to hammer that because if they were reviewing their options, it meant, A, their argument that they were being foreclosed went by the wayside. Maybe they could take over the combined company. And secondly, where was their irreparable injury? And somewhere very early on in the argument, because no one knew this testimony because the depositions had been sealed. They were confidential. Sealed isn't the right word, but the depositions were not public. I started reading this testimony and started hammering this testimony that it showed they were not foreclosed. It showed that the whole case had to go away with no conceivable preliminary injunction. I sort of remember the courtroom erupting. Maybe it was ARB lawyers, but there was a totally it got through to people. This was a totally different case than they expected it to be. And that tied very much in with the theory of there's no foreclosure here. It isn't a single person acquiring the company. It's a bunch of stockholders out there. Okay, it's a larger company.
It's not an end of
No, not
life
so.
transaction.
It isn't. This isn't Revlon. This isn't Revlon at all.
Do you remember that some of the response from the other side was that Peter's question had been unclear?
No. No, I
that
don't
was,
remember
that. That
No, I
was an
don't.
interesting way to try to deal
No,
with that.
I don't remember that.
So, what did you make of? I mean, the argument in Time Warner that somehow the shareholders had been deprived of the opportunity to vote.
Yeah, that was tricky. That always disturbed me, because now I'm trying to refresh my memory because I really haven't thought about this for a while. The original structure of the deal, as I recall, called for, under the stock exchange regulations, called for a vote. Do I have it right?
Yes.
And now you remind me, I remember I went down, or Marty and I, or somebody or other went down to the stock exchange to try to talk them out of it, that it really wasn't necessary. And there were fairly substantial arguments why in the particular situation a vote should not be necessary. And we could not persuade them. But then when I guess Paramount came along with their offer, conditional as it was, delayed as it was, everything else, it was structured so there would be no vote. And that was, to my mind, a flashpoint where we could run into real problems. And indeed, I got questioned very closely on that in the Supreme Court argument, as I recall. Well, is this proper? You took the vote away. Why? And we had answers that, best answers I could come up with were along the line, well, there was so much false propaganda out there. It was we couldn't hold the vote to need a cooling off period, and Warner wasn't going to sit around and wait for a cooling off period. But that was a tricky argument. And then the Delaware doctrine of independent legal significance, that if you do something one way and you have a vote, that doesn't mean if you do it another way, you have to have a vote. And that resonated because that is such a fundamental precept of Delaware corporate law, litigation law, the doctrine of independent legal significance. You don't spill over from one theory to another.
One of the things that I think comes across in the Supreme Court opinion, as opposed perhaps to the Chancery Court opinion, is a strong sense that Delaware companies, when they're pursuing a strategic merger transaction, ought to be able to do that without, in effect, taking on the special duties they might have if Revlon applied. And so the decision, when it came out eventually about 6 months after the argument, they said how they were going to decide it, but they didn't write and issue the decision for several months, was viewed as sort of a major statement by Delaware, trying to give strategic transactions more protection, and by inference, at least from some critics, giving management and boards more leeway to, as the court said, pursue long-term strategic goals and long-term business plans as opposed to short-term plans. Did you see this as a major framework for the argument in either?
You're reminding me. I have to look at my argument because this came up during the argument.
Oh, Sure.
Rephrase.
Okay.
This came up during the argument.
Are you in the Supreme Court now or the Court
I'm
of
in,
Chancery?
no, I'm in the Supreme Court. I thought I had. Oh, here, in fact, I have it. I went into a very risky argument, as I recall it. Or, I mean, it seemed risky because it was long term. It would take a lot of space, and you never know when you're arguing, particularly because, you know, a Supreme Court with multiple judges, someone's going to break you in with a question. So it's always a problem. I had the same thought on QVC. We'll get to it later. But I made an argument which I thought was a very, very strong argument, that they were attempting to take, the other side was attempting to take, whether it was Revlon or Unical or so on, and turn it into a rigid, mechanistic formula of money and dollars, which would totally defeat the base fundamental concept of reasonable business judgment of a board. But in order to develop that argument, what I had to do is take their experts' testimony, and who had done a comparison of dollars between the dollars that were then on the table and a projection into the future of what the time could be worth, long term. And it was billed by the other side as being conservative estimate. But they used, I think, a 25% discount rate. And I developed an argument. Unfortunately, I didn't get interrupted. 25% discount rate is the kind of discount rate an arbitrageur uses for short term. This isn't a long-term rate. So what they are telling you is that Delaware law and reasonable business judgment should be rigidly confined for short term by using this discount rate, that should control the reasonable business judgment of a board. And then I read this the other day, so I flagged it. And it's interesting because it goes to a lot of what goes on in this country.
What page are we on?
86. I think a board, as this court has indicated, after I went through this whole mathematical analysis, which somehow I don't think I got interrupted on. No, I didn't. If you go back, fortunately, well, no, Moore asked me, can't he take short-term speculators into Moore? Mr. Wachtell, I think a board, as this court has indicated, should indeed take into account, among other things, the interests of short-term speculators. They are stockholders when they acquire stock. But I do not think that you can put it, Your Honor, at a specific percentage. And then the next thing I said, and I do not think that we can survive as an economy, as a nation, or as corporations if boards are compelled to look to short-term values. It's like a peroration. It's something our firm, Marty, have ever strongly believed, and that was my opportunity to put it on the record.
And the Supreme Court, despite Justice Moore's somewhat tart questions to you on that page, that was the direction the Supreme Court was ready to move.
Yeah.
Did you feel, and this connects to a sense that some commentators looking at this period of Delaware law have expressed, that there had been a little bit of a change in the view of the takeover activity, the tremendous takeover activity fueled by, in part by Drexel Burnham, and the availability of financing for transactions that would end the existence of many traditional historical American corporations. Did you feel that the receptiveness maybe of the court in 1989 was different than it was, well, when you'd been before them 5 years earlier, and the takeover wave while you can't say it was just beginning, it hadn't driven through as much of American industry by then.
I think to a certain extent, yes. I think that the Delaware court was waking up to the fact of the evils of everything being quick shot and takeover and so on. There's this very humorous passage which got a lot of note, as I recall, in this argument. I think it was Justice Holland. I don't think I flagged it, but he started throwing me softball questions. I mean, totally softball questions. Haven't we previously held X? Haven't we previously held we could look to the long term? Haven't you previously done this? And I finally said, I think you should talk to my adversary. And, there was big laughter in the courtroom and on the TV screens. But yes, I think the answer to your question is yes. I think they had recognized you had to put some brakes on.
And let's go back for a moment to Chancellor Allen and the Court of Chancery case and opinion, because he took a somewhat different approach from the one ultimately he ruled in favor of Time and Warner, but he was very precise about saying that the issue was whether or not the resulting company would have either a control shareholder or it was going to come to the end of its existence. There'd be no control premium possible. What he said was, as long as you said earlier, as long as there's a public corporation and that corporation can be sold in the future, that
And it just has been.
and it just has been. It's a historical irony that we're having this discussion today,
Yeah.
perhaps.
Right.
But he was very precise, if you will, about locating the reason why Revlon didn't apply on a definition of what a change of control means. And the Supreme Court swept with a broader brush.
I think, but they did that, but then they said, I think, then they said additional things. As I'm trying to recall, and I don't know, I haven't gone back and read all the briefs or everything. I've done very scattered reading in preparation for this, because I'm jammed up on other things. I don't know, for example, this 25% discount rate. I'm not sure that was even argued before
Chancellor Allen.
Chancellor Allen. It's my experience as a litigator. You start off with a case, there's a complaint, there's an answer, there's depositions, there's motions, there's preliminary motions. That by the time you get into a Supreme Court or a Court of Appeals, invariably the emphasis of the arguments bear no relationship or not necessarily that much relationship to what was argued previously. There's a development process to the litigation. I think your own attitudes change, your own concepts change of where you should go. I think the arguments before a chancellor, even if you thought of it or chose to argue it, are different that you might advance in the Supreme Court. You figure a chancellor, keep it simple, he's bound by precedent, he doesn't have much leeway. Don't go further than you have to go. Whereas the Supreme Court, you could afford to open up.
Well, you get the sense reading the Supreme Court transcript that the justices from really, not that they didn't ask you very tough questions, but that they were leaning towards affirmance.
I guess so. I'm trying to remember. You always have your heart in your mouth, you never know.
That's true. They can be very tough on one side, and then they
Yeah.
turn out to be tougher on you when you get up.
Yeah,
So,
you never know. Did I think when I was arguing? I don't think I was. I think I was just thinking about making my argument, making the best arguments, time constraints. I don't think I was thinking, and I have to tell you, my experience has been, I've been in some situations where I walked out of the court and told the client, "Look, we lost this one to appeal," and then I got a unanimous decision from a court of appeals in my favor. You never know. But I don't remember. I just don't remember. Maybe I was optimistic.
well, were you more optimistic, for example, than when you left the Revlon argument?
Oh yeah. But I didn't argue Revlon in the Supreme Court.
Right, right.
Yeah. Oh, yeah.
So one.
Well,
Oh,
actually, no, because I think, but for the raise, I think I would have won Revlon before Vice Chancellor Walsh. I think that the argument that they're here with an inferior offer asking for an injunction, I think that argument, notwithstanding your skepticism and everything else I said, I think that argument would have carried the day. And the reason it didn't carry the day, even though, as I say, theoretically nothing that happened after the board meeting should make a difference as to the reasonableness of the board conduct, the fact that Perlman then raised led him, I think he even mentions it in his opinion, let him feel free to go with his previous disposition.
Time Warner, well, and as we'll get to QVC Paramount, both cases involved very well-known media companies, very glamorous businesses. There was an enormous amount of press coverage in both cases. Did you feel that the participants, the corporate folks involved, had to, in effect, play to the media as well as the court? And did you ever feel that there was a tension between those two needs?
I did not personally feel that there was any tension whatsoever. I'd never argued, before in a televised court proceeding prior to Time Warner. When I walked into court, I did not know how I was going to react. And once I got up on my feet and started arguing and so on, I was oblivious to it. It was no different than arguing anywhere else. On the other hand, as I recall, it was a stockholder lawyer who, I think he was playing to the, maybe he would have done it anyway, but he was playing to the camera perhaps a little bit. I recall he came up, what was the great line? We were playing to the aura of Time Warner and the fantastic company, and and he sort of said, well, the bathing suit issue of Sports Illustrated.
The time culture argument, and he said it's really People magazine, the People magazine and Sports Illustrated culture.
Which now, when you argue that if there was no television going, I don't know.
Have you seen, there have been some studies done which actually track the stock prices of the companies involved in real time as you and the other lawyers are arguing? Well,
that's what I was saying to you in terms of the Chancery Court. Later on, or maybe then, I don't know if Bill Allen, Chancellor Allen, put in "you can't leave the courtroom" rule in Time Warner. I just don't remember. I know since then, and maybe he did too, but I knew there were certain cases, we argued a lot of takeover cases, where when something exciting would happen in the courtroom, the ARP lawyers would run for the doors.
Yes.
So the answer is yes.
And of course, if it's televised, they're watching it on their screens.
That's right, televised, yeah. Televised. And I was telling you an anecdote before, though, you talk about how widespread this was. Unfortunately, one of our founding partners, George Katz, had died reasonably, not too long before the Time Warner matter. Totally unrelated. And the wife of one of our other partners insisted that George was a widow, go with him on a vacation. And the two of them went. It was Mary Sterling, who was a great adventurer, ended up being on some ice floe up in northern Canada, looking at seals or whales or whatever it was, and spent the day out on the ice, or the morning, whatever it was. And then, I'm told, came back to this little Eskimo village. The television was on, and they watched me arguing in Delaware. So, Yes, the coverage was ubiquitous.
And there was tremendous public excitement about it. And then for 3 or 4 years afterwards, the volume of takeover cases in Delaware seemed to decline until QVC Paramount.
Yes.
I remember when QVC Paramount became a big contested takeover, it was like the 80s are back, because it was several years later.
I remember, tell me if I'm wrong, you and I worked on it together.
Yes, absolutely.
Vividly. I didn't like your first brief.
It's probably Ted's idea. Well, how did you feel QVC should be litigated? What you obviously had a very strong.
Yeah, I had a
sense.
very strong view of how QVC should be litigated, and I called it the dog that didn't bark. I looked at the minutes, such as they were, which they were very skeletal, of the QVC, of the Paramount board. And, one second. And they were very skeletal. And I basically approached the case. I think you and I talked about it, because we must have, of course we talked about it. And I sat back and said, if I had been running that board meeting, how would the board meeting have been conducted? What should the board have known? And there were all sorts of facts that the board should have been aware of. It was that between the time they turned down a previous offer and the time of the offer they were accepting, Redstone had been buying up shares of stock, so it made the new offer look like a great offer when actually it was inferior to the previous offer. That they should know that they should know about the lockup, that they should know about the no shop clause, and so on, so on, and so on. There might be like 5 or 6 critical things, at least, that a reasonable board should know before it would decide to accept the Redstone offer. Oh, there was options. I mean, a whole bunch of things. And I insisted that I would take the first deposition of a board member, and that hopefully that would be the prototype of everybody else who was taking the continuing depositions. And my whole sequence of questions was, the first guy, well, at the board meeting, were you told X? Did anybody ask? No. No, I don't remember that. And on and on and on, just a pattern. And that, and then a perfectly continual pattern continued on every other director. Because in fact, they hadn't been advised and nobody had asked. And that became the brief, particularly I think in the Supreme Court. It was the dog that didn't bark. We had no affirmative facts. we had the facts of when a raise came or when, but what did we have to show that the board didn't act reasonably? And we had no affirmative evidence in act easily. It was only this, what we created. You should have been told this, and you weren't, and nobody bothered to ask. And that was powerful, powerful, powerful. I think in winning that case in the Supreme Court. Yeah.
That it was a very clear question. Sumner Redstone was going to have, control.
Yeah.
And that was what should be emphasized. It was almost like there was no factual dispute about that. So I think we wanted to argue it as a cold, undisputed facts, like summary judgment motion, but without any of the testimony. And you wanted to go in for the jugular, and these people, But anyway, why don't we go back on the?
Okay.
Because I was actually going to approach this a little bit, though, not from the standpoint of our internal brief writing. Back on the.
That's what makes what we do.
So,
I mean, even though intense pressure, it makes what we do so much fun. That you have the different points of view and you battle them out, and
Yes, and everybody has their say, and so One of the thoughts that some observers have had about what was going on inside the Paramount boardroom was that they were in effect operating under a mistake of law. They believed that they had no legal responsibility to deal, or their advisors believed they had no legal responsibility to answer any of the questions that you refer to or to provide the board with information, because in their mind they were operating frankly under an unreconstructed Time Warner approach to life, where if you're doing a strategic deal, you don't have to pay attention to somebody who comes along and wants to buy.
I think it was more arrogance. Maybe. I think you had some of the Redstone arrogance.
Do you remember some of the? I think you did good work.
You know, there was even a memorandum.
Donald Orsman's memorandum.
Yeah, you know, which really laid out what was wrong with what they were doing, which they never produced in Discovery, but we got it because Lazard had it, and Lazard produced it in Discovery. And he was obviously unhappy with what was going on in the boardroom from that memorandum.
So in that case, you had a number of public statements by Mr. Redstone and Mr. Davis. The marriage that shall never be torn
Yeah.
asunder. It'll take a nuclear. I'm sure I'm getting these wrong, but they'll take a
No,
nuclear weapon.
that's what I'm saying. I
Yeah.
think there was a lot of arrogance.
Do you think those out-of-court statements, well, sort of possibly intended for the media, nonetheless hurt that side?
Well, it certainly showed, if you're in a Revlon, not Revlon, in a unical mode, or, you know, whatever it is, that they didn't feel that they had to pay much attention to anything. That's what I guess what I'm saying. I think it was bad lawyering also. I mean, because there was no reason to think that Time Warner should control it.
Well, their argument was that as long as the stockholders continue to have a significant ongoing equity interest, that the fact that voting control has changed is not something that was mentioned, for example, in the words of the Revlon decision.
Yeah, but I was hammering the fact that that the board had not negotiated for any protection for the minority that was going to be left in. So Redstone had full power to get rid of him at any price he wanted, any which way. He had a majority. He could merge, you know.
And
He could merge them out at 10 cents.
But their answer was that would be subject to entire fairness, and the Delaware court could remedy that.
I don't know how much the public statement certainly did not help them. I don't think they were determinative.
So one thing that comes out clearly was QVC Paramount was a rare instance, at least in that period, not the only instance, but a rare instance where our firm was the plaintiff and
Yes.
breaking up, essentially trying to overbid an
Yes.
existing deal.
Yes.
How did you feel? Was it more fun to be a plaintiff?
No. It was very hairy in Chancery Court. I mean, we were arguing in Chancery, and as I recall, they were going to close at midnight. So being a plaintiff in that posture was not relaxing or fun at all. And I think that's when we got a temporary restraining order or preliminary injunction or something or other. No, that was hairy. In fact, they were and they were arguing, well, it's not a fait accompli, the board could do something, and we were making a mockery of that. What do you mean you've delegated to management the power to pull the pill and do everything else? You're going to close at midnight. What do you mean the board is going to intervene? But it was touch and go. I mean, who knew that the vice chancellor was going to go with us?
Did you feel there was a particular legal argument, or piece of evidence that you thought really hit the vice chancellor's decision-making
I don't remember.
and helped us over
I
the
know,
top?
I remember how I argued in Supreme Court, but I don't remember what I particularly hit in Chancery. And I haven't gone back to read it.
Sure. Well, one of the things I noted when I was reviewing some of the materials was
Maybe you can refresh me.
well, and I'm not suggesting this was crucial, but it was an interesting thing that Paramount did, that they were a little bit cagey about what advice they were asking for from Lazard, and they brought in Booz Allen
Yeah,
to do a report.
yeah.
Do you remember that?
Yes.
Do you think that was important?
Well, I remember two things, and maybe my memory is wrong, or maybe I'm conflating cases and it's a different case altogether. But I remember arguing either in Delaware Supreme Court or in Chancery in some matter or other, and somebody had brought in either Booz Allen or the equivalent of Booz Allen, and a judge asked me, well, what do you think about this? And I said, aha, and proceeded to quote the statute from Delaware which says who a board is entitled to rely upon, and it didn't include people like Booz Allen. And I was prepared for it, and I said to myself, wow, I'm so glad you remembered to prepare for that one. We certainly hammered the fact that they never said that the offer was superior, et cetera, et cetera. That Lazard never gave an opinion that the Paramount offer was, that the Viacom offer was superior.
There was a lot of talk, as I recall, about an offer could be inadequate simply because somebody might later offer more, as opposed to being sort of absolutely inadequate. But we may be getting into the minutiae.
Yeah, the other thing, it goes back to what you asked me before, being a plaintiff. I don't want to say frustrating, but it was very troublesome about what we were doing throughout the matter, not just at the time of argument, was they had a head start with us. I guess it's in terms of Hart-Scott.
Yes, that's right.
And we couldn't catch up. So we needed an injunction. And we were saying, as long as nothing happened, they won. Because they could close and we couldn't.
Do you recall any difficulty in thinking about what the shape of relief you would be asking for in that case, or how the injunction would be shaped?
I'm sure we debated it.
Because one part of it was that, on the one hand, the likelihood of a court saying you have to sit down and negotiate with QVC, that wasn't something we asked for.
Well, they had already ostensibly recognized that, but then defied it. If you recall, 1/3 of the way along the sequence of things, I guess they woke up a little bit and said, oh, well, you have fiduciary duty to, you have a duty to talk, but then they didn't. No, I'm sure that there had to be a debate on the scope of injunctive relief we should ask for. It had to be effective, and to my mind, it had to be as narrow as possible to be effective, so you didn't give a judge more of a burden than the judge needed. That's always the reason I'm not remembering this specifically for this matter, but that's always my thing, don't go overboard.
And interestingly enough, it included...
Oh, he knocked out the option.
The option and the pill.
Yeah.
The idea was if you
Right.
pulled the pill for
Yes.
an offer here, you had to pull it for an offer above that.
Well, that's when, I don't know if you want to talk about the argument before the Supreme Court.
Sure.
When I sat down to prepare the argument for the Supreme Court, I had a concept in mind that I wanted to argue. And again, just as I was saying, arguing a 25% discount on a long drawn out thing is very scary because you will get interrupted. I had a thought of how to open the argument in the Supreme Court, which I thought was fantastic and also scary as hell because it would take a lot of time to develop and maybe never get, someone gets impatient with doing it, they never get to do it. And as I recall, it was something along the line of the Delaware Supreme Court is an interesting body. It's a fine court. It's always been a fine court. And it is very much caught up with Delaware corporate principles, with its own majesty, and it's entitled to be. I'm not saying that in a negative sense. But if you can argue and play to that attitude of the Delaware Supreme Court, I think you're always ahead of the game. And particularly if you come from New York. You're not a Delaware lawyer. And the concept I came up with, and I eventually used it, and I think to great effect, but it was scary, and I haven't read the transcript, was something along the line, there are 3 different prisms of this court's jurisprudence through which you can view this case, and they lose on all 3. And it was I guess either Revlon, Unical, household, proper use of a pill, and whatever the name is, escaped my mind, informed board.
Van Gorkum.
Van Gorkum. And then I proceeded, hopefully somewhat pithily, to spell out each one. This is my opening. And that's scary as hell. It worked. I did not get it. To my recollection, I did not get interrupted, and it sort of laid the foundation then for the whole argument. I thought it was an incredibly effective way to start the argument. But it was scary.
It actually raises a question that I meant to ask about all 3 of these cases, but now that we're on the 3rd, if you remember about any of them, were any of these cases situations where you thought either at the Chancery Court level, or the Supreme Court, at least for the ones you argued in the Supreme Court, that the oral argument was critical in the sense that the panel came in undecided?
Didn't know. Don't know.
So each one of them was a situation where you didn't have a strong feeling as to which way the 3 judges were going to go.
I didn't argue Revlon, Supreme Court.
Correct.
I had a strong feeling, not before I walked into court, but during the Revlon argument in Chancery, that I was in trouble. I did not, again, going back, we talked about it before, I guess I did not feel I was in serious trouble on Time Warner. And I don't really recall that much of the courts. As I said, I didn't go back to read the transcript, so QVC is dimmer in my recollection. Don't know. And of course, in one, in both Revlon we were appellant, QVC, Time Warner and QVC we were appellee in each case. One we had beat off an injunction, the other one we had obtained an injunction. I don't know.
A lot of time was spent on the QVC appeal about whether or not Viacom had vested rights, if you will, in the option. Do you remember that argument? I mean, you weren't direct. It wasn't your argument.
No, I don't recall. I remember, I mean, obviously that was in the issue, and I know the chancellor had, I guess the chancellor a little bit surprised us by giving us that victory. I don't know if if you recall that. I think we were a little bit surprised that he went that far to knock out the option. No, I do not recall extended argument of that. But as I say, I haven't reread the transcript, so I'm kind of cold on it.
Are there other things? We talked a little bit about some of the evidence in QVC. Was there anything that happened in terms of surprises that you recall, other than the Oarsman memo surfacing in Lazard's files, and the directors who hadn't been advised on the subjects that you asked about? Any sort of key facts?
Maybe you could refresh me if there was. I don't recall any other surprises, so to speak.
There was and I'm not saying this was critical, but there was a major theme, of course, about management and management's preferences, and that was, again, a theme that you see in all three cases. In Revlon, there was a feeling that even though the company was being broken up, that the board preferred Forstmann Little to Pantry Pride. There was certainly a lot of emphasis on the so-called time culture in Time Warner, and there was a feeling also with respect to Mr. Davis that he had a strong preference as to how management should be arranged.
Well, one of the things, there was testimony from Redstone, you're now reminding me, which I thought was damning for their side. And it was that they were, for 3 or 4 years, this was actually damning testimony, I've forgotten this, that for 3 or 4 years he had been courting Davis and had gotten nowhere. And then they sat down in that spring and had negotiations, and wanted to talk to Davis about price. And Davis essentially said, I don't want to talk about price, we got to talk about who's going to run the company. And that was damning.
Well, the whole management issue is something that
No, his role, what's my role?
Yes, exactly. Yeah. Am I going to run the company?
Am I going to run the company, yeah.
And once that was solved,
everything
the
fell into
economics,
place, yeah. Price was inconsequential. The purchasing of the stock, I thought, was just a home run. I don't know how much weight the court gave to it. Because if you actually looked at the two offers, which were a combination of stock and cash, the second offer in the fall was inferior. In other words, in terms of number of shares and amount of cash, it was worse than the one that had been rejected back in the spring. And the only difference was the stock had gone up like 30%. And the reason the stock had gone up 30% was Redstone had been buying heavily. Now that, to my mind, was absolute dynamite. It was not, I don't think the board was, it was not in the Lazard book that was given to the board. Whether it was mentioned, if it was mentioned at the board meeting, it would have had to be fleetingly and without any significance. But I don't remember the courts giving that much weight to that. I don't remember. One would have to read, one would have to read the opinion.
It was heavily argued, but sometimes when it's uncertain from the record, and as you say, it's a preliminary injunction record, and by the time you get, you may recall that at the Court of Chancery level, the Vice Chancellor felt that the Paramount board had, I'll be colloquial here, had sort of done okay in the early stages. And it was only, I forget the date, but there was a particular date, and he said after that, they
I've
failed.
forgotten that.
Yeah.
Yeah, and we'd won, so you don't get too dismayed by winning. But I wasn't happy that he gave them a reasonably clean bill of health because, for example, how could you possibly say that when this offer was really worse than the offer you had rejected, except for the fact that he bought up the stock?
Right.
So, yeah, you remind me, I forgot that. I wasn't happy with that little fillip in the opinion.
In Time Warner, it wasn't so much the Warner side of the argument, but the Time side, if you will, spent a lot of intellectual capital on the notion of there being a time culture, which or one of the purposes of the transaction was to preserve. How did you feel that played with the court or played into the wider legal issues?
The reason I'm hesitating is I had a very strong feeling on that subject, and it was an episode that occurred during the deposition process, which very much centered upon that, but I don't think I'm comfortable talking about it.
Very good. There's a history in these interviews of the interviewee at least once saying, "I know the answer, but I'm not going to tell you."
I thought the time culture was critical, and I made my views on that known to Time.
Very good. Any other thoughts about your career as a premier litigator of Delaware takeover cases?
Not really. I mean, I litigated others. I'm sure I could. What's the film people? The instant cameras.
Kodak.
Hmm?
Polaroid.
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 I litigated Polaroid. I litigated. I tried to get the Delaware court to intervene and stop what was going on down in Texas on
In Texaco Pennzoil.
in Texaco Pennzoil, and couldn't persuade him to enjoin Texas because we saw a disaster looming in that matter, and we were right. No, I had other takeover. Offhand, I'm just not remember there were other takeover matters down in Delaware beside these three.
Do you remember after the QVC argument? I think that was a closed courtroom, and I may be wrong about this, but I remember Barbara Robbins coming out. Some of us were waiting in a nearby building, and she gave like the thumbs up sign indicating we thought we'd won.
Yeah, I think I remember that.
You were being interviewed there were TV cameras all around the exit of the old courthouse on Rodney Square, and you weren't in a position to do that, but she.
And I wasn't about to say very much either.
Yeah.
I didn't want to get anybody's nose out of joint. I have the picture in my office, but I didn't say very much. Yeah, you remind me of that. I remember that.
Very good. Well, thank you for.
Well, it's a lot of reminiscing. It's very interesting. It was fantastic time. And present-day times are different, but maybe no less fascinating, just in different directions.
Well, we're still still trying to figure out what some of these decisions mean 30 years later.
Yeah, yeah. They were seminal. No other question about it. In the Revlon, as I say, was certainly a seminal decision, which I have no quarrel with the doctrines. The decision, well, I've already said my say on that.
Well, when Revlon first came down, people thought the word auction, as used in the opinion, meant an auction on the courthouse steps. And it did take a number of years for the Delaware courts to settle down into a much looser, broader interpretation of what was required under Revlon. And
yeah. Look, the Delaware courts, I think have acted spectacularly at that time, and since I'm a big fan of Delaware courts and Delaware courtrooms. And certainly in this series of cases, and Van Gorkum, and obviously Unical, it's a seminal group of cases that are fundamentally very, very sound.
And the Household case, all within 18 months.
And household. Yeah, household. Our partner George Katz argued household. Yeah. Were they all?
Well, not QVC.
Not QVC.
And Time Warner is 3 years later, but the Van Gorkum, Unical, Revlon, and Household are all within.
Well, that is amazing. I had not realized they were that tightly put together. It's an amazing body of law.
Very good. Well, thank you for your time and for being so entertaining as well as informative.